Spencer was arraigned on April 24th on this charge. Ms. Fervento is correct. The allegations arise from March 22nd. The complaint was authorized by the prosecutor's office on April 10th and looks like sworn to by law enforcement on April 15th. At the time that Mr. Spencer was arraigned, I set bond at $10,000 cash surety. I did find him as a threat with the conditions of no contact, standard conditions, and not to purchase or possess any firearms or weapons, or not to act in any threatening, intimidating behavior. MCR 6.106, which sets forth the bond factors when considering pretrial release, lays out that the court should consider any prior criminal record. Ms. Dull did mention some of that record, but according to the court's notes, in 04, there was a possession of marijuana, 07, possession of marijuana, operating while intoxicated, and attempt to flee third. In 12, an operating while intoxicated second. In 15, an operating while intoxicated second, driving while license suspended second, and operating while intoxicated with an occupant less than 16. In 17, there was an operating while intoxicated third, driving while license suspended second, operating without security. In 19, an aggravated domestic. In 22, a domestic second and a jostling. In 23, a malicious destruction of property, 200 to 1,000, assault and battery. And 23, domestic violence and attempted resist and obstruct. 24, driving while license suspended second. Then another driving while license suspended second. No, I've got that wrong. Driving while license suspended in 24. Then another driving while license suspended second in 24, and another driving while license suspended second in 26. A record of appearance or fail to appear, flight to avoid prosecution. In the court's mind, I don't remember any fail to appears. However, the praxis indicates that there are at least 2 fail to appears. Flight to avoid prosecution, potentially that could be what the attempted flee third was back in 07. History of substance abuse or addiction. And we've got the possession of marijuana cases and five convictions for drunk driving. Character, nothing's been presented regarding that. Mental condition, nothing's been presented. Reputation for dangerousness. Mr. Spencer has been convicted of five assaultive type crimes plus a malicious destruction of property crime and an attempted resist and obstruct. Seriousness of the offense, he is charged as a domestic violence third. That makes it a 5-year felony. Then the habitual fourth makes it a life offense. Probability of conviction, I'm not going to weigh in on that, and likely sentence. Nobody has presented his scoring guidelines to me today. Employment and financial status and history, Ms. Fervento reports that he at least was employed. There are no responsible members of the community to vouch for the defendant. Ties to the community, family ties, relationship, and length of residence. The court is aware Mr. Spencer has been, I believe, probably a lifelong resident, with the exception of maybe a few months he was residing out of state. And I gathered that from an arraignment we had a short period of time ago. And then any other factors, risk of appearance and danger to the public. While I do realize that this case arose back on March 22nd, it was recently charged and he has been recently arraigned. I do show that the defendant has 3 prior domestic violence convictions in his past, ranging between the dates of 2019 and 2023. I do still consider him to be a threat to the community, and I believe bond is appropriately set where it's at, so I will keep it where it currently is. Anything else for the record, counsel?
No, Your Honor.
No, Your Honor, thank you.
All right, thank you. This is case number 26-1412-FY. Appearances, counsel.
Nate Carnes on behalf of the people.
Robert Hertel from Mr. Cornell, who joins me to my right. I am filling in for Mr. Champion and did meet with Mr. Cornell to let him know earlier Your Honor.
All right, Mr. Cornell, Mr. Champion is your appointed counsel, but for whatever reason, he's not available today. So are you okay with Mr. Hartel filling in for him today?
Yes, sir.
All right. Counsel, we're here for a probable cause conference, but shortly before taking the record, I was presented with a recently filed motion for forensic examination regarding competency and asserting a insanity defense. I guess my first question then, Mr. Carnes, are you prepared for a motion on this today, or do you want some time to review and respond if necessary?
Your Honor, I don't need time to review or respond. I think it's the defense is requesting competency. I think it's appropriate for the court to enter an order consistent with that. I don't oppose it.
All right. So then we'll set aside the PCC then. No objection, Mr. Hartel, your motion regarding competency. The insanity defense, that's kind of an automatic trigger, but competency.
Thank you, Your Honor. As the court did make a note of earlier, I'm not as familiar with my client as Mr. Champion. However, I have met with him. I have, without getting too personal, I'll say I've seen some things that would still be of concern. He did, without mentioning anything protects my privilege, he did mention that he has issues with his memory. I did have some, I don't want to say anything rude, I want to be cautious, but the interactions I felt were worthy of analysis. I do believe Mr. Champion goes into a bit more detail in his motion as well, because he has had more interactions with Ryan here, but I'm always the mindset of when in doubt, it's best to be double sure as much as possible. Have the experts review it. I know I'm not a medical professional. I would never pretend to be a medical professional, but I definitely would want all my clients to make sure that they are in the right state of mind, that all their rights are being protected, and that, although I don't think mimicry is a situation I'm concerned here, I do have some other clients, just for compare and contrast, who I know mimic that they can understand. Based on my interactions today, I don't believe that's a concern. I believe my client's aware of the fact of his limitations. We just want to make sure we know exactly how deep those limitations go. And only a properly trained professional can tell us that for sure. I'd ask the court to err on the side of caution. Thank you.
So, Mr. Hartel, bear with me because I'll be honest, I did not have the ability to review the motion in its entirety, given how short notice we had here. But I see in number 5, it says there's a full guardianship.
I should have brought that up before. I apologize. I did have a discussion at my office. Yes, I don't believe, is your mother here today?
Right here.
Could you join us? It's okay. I shouldn't.
Yes, she definitely needs to be here.
I should have caught that. I apologize, Your Honor.
Will counsel approach?
Yes, Your Honor.
Charged with failed to stop after a collision. He was released. He posted bond. He was in 26-511. He posted a $25,000 cash surety bond. And in the misdemeanor file 4028, he posted a 510% bond. I don't have any violations with he's not testing. But given the allegations and the seriousness of the offense, the court will issue a bench warrant.
When did you post bond?
So bond was posted in the felony file on April 27th. 27th for both files. That's when the surety was filed.
He just tested today and was given EOP paperwork to look into
He tested
for
today.
community correction.
All right. So I'm going to change this to a show cause then. If he tested today, I'm guessing it's, I don't know what, but we'll set it for a show cause. Anything else for the record? Ms. Carey.
No, thank you.
Is that
I think she-
All right, we are back on the record in the People versus Ryan Lee Cornell, case number 26-1412 FY. Our off the record conversation dealt with whether or not there was truly, in fact, a guardian appointed for Mr. Cornell. Staff has just obtained for me letters of authority appointing, is it Bonnie Kranz? All right. With full legal authority. So counsel, as we had discussed, because we were not aware that Mr. Cornell was under guardianship at the time of the arraignment, Mr. Carnes is.
I'm covering.
Oh, you're going to cover for Mr. Carnes? All right. So Ms. Dahl is stepping in. Because we weren't aware that there was a guardianship, we need to have him arraigned then on the complaint. So you're Bonnie Kranz, correct? All right. And you are the legal guardian for Mr. Ryan Lee Cornell.
Yes.
All right. So I have a complaint that alleges that between the dates of April 27th, 2025 and January 21st, 2026 in the city of Cadillac for Wexford County, it is alleged that Mr. Cornell committed the offense of child sexually abusive activity, aggravated distributing or promoting. That is a felony punishable by up to 15 years in prison and or a fine of $50,000. To be clear, $50,000 with SOAR registration. Count number 2 is sexually abusive material, child sexually abusive material, aggravated possession. That is a 10-year felony and or a fine of $50,000 with SOAR registry. Count number 3 is the same as count number 2, so a 10-year felony and or a fine of $50,000 with SOAR registry. Count 4 is the same charge. Counts 5 and 6 are child sexually abusive material possession. Those are both 4-year felonies and or a fine of $10,000. In count number 7, that's use of a computer. It looks like 7 and 8 are both the same charges. Use of a computer to commit a crime with a maximum imprisonment of 10 years or more, but less than 20 years. Those are both 10-year felonies and or a fine of $10,000 with reimbursements to governmental expenses. And consecutive sentencing may be imposed for the underlying conviction. And count number 9 is using a computer to commit a crime with a maximum imprisonment of 4 years or more, but less than 10 years. That is a felony punishable by up to 7 years in prison and or a fine of $5,000, reimbursement for governmental expenses. And again, consecutive sentencing may be imposed. Do you understand those charges and the potential penalties? Maybe not the basis of them, but that's at least what he's been charged with and what those potential penalties are.
Okay,
Do you understand that?
I believe so.
Mr. Hartel, because we're probably putting her on the spot here, let's put Mr. Cornell back in custody, and why don't you take a moment to discuss the matter with.
Absolutely, Your Honor.
With
Just
guardian.
aware I'm also on lepers, in case we'll try and do that one next.
Okay.
Okay. Let's speak with you, sir. All right, court next calls the People versus Andrew Smith. This is case number 26-1524 FD. Appearances, counsel.
Nate Carnes on behalf of the people.
I'm Jeff Harrison. I'm here on behalf of Mr. Smith. We did turn in a pretrial form. Despite appearances, it would appear that we are in a position to perhaps accept that offer. The problem is there was a blood test. We don't have anything to support the factual basis yet.
Was there a refusal of PBT?
There was not.
So was there?
The PBT was below 0.08.
Oh, okay. I see what you're saying. Okay.
Right. So right now I couldn't support a guilty plea if I wanted to, and I don't.
All right. Mr. Carnes?
And the allegations are a combination of alcohol and prescription medication.
Specifically Xanax, but we'll sort that out when we get the lab.
All right, so we definitely need the lab then.
Yep.
Or, Your Honor, we could proceed with a visibly impaired second today.
Is that
It's
something
the
you're
same
interested
outcome
in?
as far as the people are concerned.
We don't, at any rate, we don't have the substance use assessment. So I would prefer, I appreciate Mr. Card's offer on the fly, but he needs to get with Brian and get with some services in the interim as well.
So my experience is if we're moving forward with the intoxicated, the lab will come rather quickly for the alcohol, but it'll probably be delayed for the controlled substance aspect of it.
Right, and that's the issue, unfortunately.
Mr. Carnes, you know when the items were submitted to the lab?
I don't. In fact, I think this is
Looks like it's Miss Lawrence's case.
Lawrence's case, so
It
I
is.
think she's next door in probate, so I'm.
Okay.
It would appear from the report that they were timely submitted.
All right.
I couldn't give you a date, obviously.
So, Mr. Harrison, I'll leave this, then I guess the ball's in your court. Do you want to set it for a preliminary examination, or do you want to set it for a plea and sentence with the offer that was just made?
That is sort of the dilemma.
Or do
I,
you want to
right
reset,
now, pardon me?
want to reset for a probable cause conference given the new offer?
We could do that. I just would like to keep it moving in some direction. It's our understanding that we're no longer deferring.
So you rejected the offer,
So we rejected the offer, but I wanted to put it on the record that that was not
right?
because of the offer, it's because of the circumstance.
So, obviously, if we're moving down the prelim track, we're gonna have, my gut tells me we're probably looking at least probably a 3-week adjournment and maybe more if we're gonna have to wait for that controlled substance to come in. So do you want to do that, or do we want to reset it for a probable cause?
To me, it's 6 of one, half a dozen the other.
I would strongly prefer a reset for a probable
Okay.
cause, so we don't have to worry about subpoenas if it's just gonna play out anyway.
If there's a strong opinion in the room, then I would defer to that.
You want to reset next week or the following week?
If possible, 3 weeks, given how long the MS people.
Because we know what we're waiting for.
All right.
That's some consideration to Mr. Smith. He is renting a room here in town. So we're trying to get him moving along as well. But
So what I'll set it out. We'll set it out to. I can't believe I'm saying this, but 3 weeks out, it's the 26th already. We'll set it out to the 26th. Obviously, in between time, and Mr. Harrison, if you decide that, or Mr. Smith decides that he wants to take that latest offer, you certainly know how to get in touch to get a plea and sentence done.
absolutely.
And we can always take the plea without having had the assessment done.
Right.
So.
I understand that. I'd prefer not to, but I understand.
No, all right. So we will reset it for a PCC on 5/26.
Excellent.
We're waiting for labs. Weekly before.
Thank you, Your Honor.
All right. Anything else for the record then?
No, that's good.
All right. So Mr. Smith, you can stop out at the front window where you checked in and get your next court date. Okay.
Sure.
All right. Thank you. Court next calls the people of the state of Michigan versus Dylan Yawarski. All right. Get caught up on my docket here. This is case number 26-1438 FY. Appearances, counsel.
Please it all for the people.
Thank you, Honor Taylor and Anna Pierre-Vento on behalf of the defendant who joins my counsel table.
Counsel, we're here for a few matters. One is a probable cause conference. The other is there has been an amended complaint filed that the defendant will need to be arraigned on. And then it looks like he also has a bench warrant for a bond violation that he'll need to be arraigned on. So were the parties aware of all those issues?
Yes, Your Honor.
Yes, Your Honor, and I've discussed them with my client.
All right. So let's do step by step here. Let's take the amended complaint first. Sir, I have a complaint, an amended complaint that alleges that on or about April 22nd, 2026 in the city of Cadillac, Wexford County, it is alleged in count number 1 that you committed the offense of possession of methamphetamine. That is a felony punishable by up to 10 years in prison and or a fine of $15,000. In count number 2, it's alleged that you committed the offense of possession of a narcotic, in particular cocaine, in an amount less than 25 grams. That is a felony punishable by up to 2 years in prison and or a fine of $2,000. Then counts 3 through 5 are what has been amended. Count 3, it's alleged that you committed the offense of controlled substance possession of an analog, in particular oxycodone. That is a felony punishable by up to 2 years in prison and or a fine of $2,000. In count number 4, it's alleged that you committed the offense of controlled substance possession of an analog, in particular hydrocodone. That is a felony punishable by up to 2 years in prison and or a fine of $2,000. And in count number 5, that you possess the controlled substance LSD. That is a misdemeanor, punishable by up to 1 year in jail and or a fine of $2,000. In addition, the people have charged you as a habitual second offender, meaning that you have at least one prior either completed or attempted felonies in your past. That makes the 10-year felony punishable by up to 15 years. The 2-year felony, everybody's making me do math here. Punishable by 3 years, and 4-year felony will be punishable by up to 5 years. Do you understand those amended charges and the potential penalties? I'm sorry? Well, do you understand that based on the information the prosecutor has, that they have amended the complaint to add those charges and what the potential penalties are?
It's to my knowledge, sure, but not to my knowledge.
All right. Do you understand that that's what you've been charged with?
To an extent.
I'm sorry?
To an extent.
All right. What don't you understand?
The added charge.
Do you understand that based on the information that the prosecutor has, whatever that information has, that they've amended the complaint to include those charges? It's not saying that you're guilty of those. It's just saying that you've been charged with that. Do you understand that?
Yeah, it was under my consumption.
Okay. I'm sorry, I can't hear you.
It was under my consumption that it was for the other two until those came about.
Okay. All right. And okay, so you do have the same rights that you had before. So we will enter the not guilty plea and we'll continue the appointment of counsel. Now that gets us to the bond violation then. It's alleged that you are in violation of your bond by failing to appear for a drug test as ordered on May 2nd, 2026. You do have the right to have a contested hearing in that regard, in which the prosecutor would have to prove to the court that you did in fact violate your bond. Or you could plead guilty to the violation. Ms. Firavento, how do you wish to proceed with the violation?
Thank you, Your Honor. We would like to plead guilty to the mistest on Saturday.
All right. And then I also have, I'm not sure if the parties have received, Mr. Jaworski was tested this morning and tested positive for THC. Everything else was negative, just so the parties are aware. Ms. Dole, do you have any objection to taking a guilty plea to the bond violation?
I do not.
All right. Mr. Jaworski, it's my understanding, based on what Ms. Firavento said, is that you plan on pleading guilty to the bond violation. Is that your intent today?
This courtroom moment starts like a normal bond hearing. But within minutes, it turns into a complete breakdown of a defendant's criminal history. A man asks the court for a lower bond so he can get out of jail and return home to help take care of his children. His attorney argues that the current charges aren't the most serious allegations imaginable and says he's willing to follow strict conditions if released. But then the judge starts reviewing the defendant's record, and the atmosphere instantly changes. One conviction after another. Drunk driving, suspended licenses, assaultive crimes, resisting police, domestic violence cases stretching across multiple years. And the more the judge reads, the more serious the situation becomes. Then comes the turning point. The judge points out that this isn't just one mistake, it's a pattern. Multiple domestic violence convictions, multiple alcohol-related offenses, prior failures connected to court appearances and probation issues, and now the defendant is facing another felony charge that could potentially carry a life sentence because of habitual offender enhancements. That's when the judge makes the decision crystal clear. I consider him to be a threat to the community. In that moment, the request for leniency is over. The judge refuses to reduce the bond and warns that public safety comes first. Because in court, second chances become harder and harder to justify when the same behavior keeps happening again and again. So here's the real question. When someone has a long history of violent or repeat offenses, should judges prioritize rehabilitation or public safety first? Like and subscribe for more real courtroom moments.